Madam, you have to be very careful when you draft. If that is truth, then at least that lawyer must be notified. One can go to the Bar Council and he can make a complaint against him that he omitted.
But my lord, subject to correction.
That's why I said that these lawyer must be heard. Then what will happen? Do you realize?
My lord, I bow down to everything that is falling from my lord.
Then
My only.
why not he should be heard? I am sending you a duly executed Vakalatnama. You put a no objection on that.
Well within his right to withhold the objection. That is the practice.
No, madam. If you inculcate this, I am telling you wrong notion.
No, my lord. We kindly.
You can't withhold the no objection. If the client wants to withdraw, you should. Where is your client?
My lord, there are some things, my lord. It's little bit, my lord, on the murkier side.
After reading this,
Two things, my lord.
Mr. Mallik,
Yes,
after
my lord.
reading this,
Yes, my lord. Now, my lord, kindly, my lord. Two things, my lord. Two things.
where is your client?
Two things, my lord.
Where is your client?
My lord, he's at his home, my office, my lord. I don't know, my lord. My lord, two things, my lord. My statements in the condemnation application
I'm not.
are not untrue. Kindly seize that. It's not untrue. Kindly seize that, my lord. Whatever he has said in the reply, in the letter,
He has robbed you. He has robbed you.
I am not there. I was not there. So, my lord, I don't know. I have also have to have a.
Will you say that this is wrong?
My lord, I was never there.
Sorry.
I was never actually
he has
there.
indicated your name also.
Yes, I know that. Well, I've seen that. That's the
Yes.
reason more.
Then-
that is the more reason
Then-
not there.
No. Is he a practitioner of this court? No,
Yes, my
obviously.
lord. Yes, my lord. He
He has
does.
an office here.
Yes, my lord. He has.
Can you contact him to come here immediately?
My lord, may I go outside and call him?
I have a strongest of reservations when any allegations against the erstwhile advocate is made. And if we allow this application, that means impliedly we are accepting all those allegations to be true. Madam, you have to be very careful when you draft.
My lord, if I may, please.
If that is truth, then at least that lawyer must be notified and he must stand by these allegations, or he must refute
Fine.
the allegations.
Fine.
That's my strong view.
I'll bow down. My lord,
This
with the
can't be-
humblest,
this
may I
can't
make
be.
one humble submission, my lord. The section 5 application, my lord, firstly, makes no allegations against the
Oh,
previous
then
applicant.
how we directed?
My lord, if I may place, if my lord sees my lord's last order,
Correct.
my lord has specifically referred to paragraph 5
Five.
of the petition.
Yes.
My lord, before that, may I also place paragraph 3 of the condonation. There arose certain differences of opinion between your petitioner and the erstwhile advocate on record. My lord, is it apparent from Mr. Das's email that is absolutely correct? Therefore, my lord, no allegation as to his conduct, due to which your petitioner decided to change his advocate on record. However, the Honorable Court was closed from such and such to such and such, normal functioning resumed on such and such, during which time your petitioner could not engage another advocate on record. My lord, I place paragraph 4.
Then
My lord, I am coming. Your petitioner received the no objection from the erstwhile advocate on record on or about January 19, 2023. My lord, that is verifiable from the Vakalatnama, which is before.
no difficulty.
Thereafter, the petitioner signed and executed Vakalatnama in favor of his present advocate on record. That much is also part of record. Thereafter, my lord, counsel was instructed to draft. Now, my lord, I come to para 5. It was thereafter discovered that the erstwhile advocate on record had omitted to apply for the certified copy of the impugned order. My lord, in para 5, this is the only sentence, and if my lord kindly takes Mr. Das's email, he has admitted as much that he had not applied for the certified copy. My lord, my humble submission.
His statement, the explanation is
Yes.
why?
My
Because
lord,
your
which is-
client.
I have made no allegations against the previous. I have
No,
only stated that he has omitted.
the act of omission is also an allegation.
My lord, I have not stated.
It's a dereliction in discharge of the solemn duty
I bow down,
of
lord.
an advocate on record.
My lord, if I may.
This will not be taken in that, the simplest way. This can't be done. Sorry, we can't accept in this way. Omission has a far-reaching consequences. One can go to the Bar Council and he can make a complaint against him that he omitted.
But my lord, subject to correction.
That's why I said that these lawyer must be heard.
My lord.
Because ultimately, if somebody goes, then he has to defend. And there is a acceptance by a court. There's a judicial order which accepts those allegations. Then what will happen? Do you realize?
My lord, I bow
Then-
down to everything that is falling from my lord.
Then
My only
why not he should be heard?
My lord, maybe, my lord, if my lord, this word, my lord, is my lord, the difficulty, my lord, maybe come back with a fresh application with regard to my lord, one, my lord. Why, my lord, may I say, my lord? My lord, why, my lord, I'm saying, my lord? My lord, actually, my lord, whatever statement has been there, I was only, no, I've got the letter, I've seen the letter. I was, my lord, I was there before the NCLT. High Court, I was not there at all. I'm coming in the appeal only. Only in the appeal I got briefed, my lord. For the NCLT, I was there, my lord. I've drafted the petition. I know it very well. I can say that even. But High Court, I was not there at all. Never there. Number one. Number two, my lord, is that, my lord,
Where is he?
my lord, he is, my lord, I called him, my lord. He is in Bellevue Hospital, my lord. His mother is going under dialysis, my lord. So therefore, my lord, he is there in the hospital. And that is the reason, my lord, he has sent the electronic mail. That is the reason, my lord. Issue because he's, my lord, he says that, my lord, if it is kept at 1:30 odd, or my lord, he will be, my lord, coming from the Bellevue Hospital, my lord. As far, my lord, I have understood from my clients, my lord, there is no allegations as such anything anymore, my lord. Yes. No allegations anything anymore.
Where is Mr. Ritoprato Mitra?
My lord, I have tried to call him, my lord. I'm not getting through his phone number. I asked my junior to in the bar library also, my lord, he's not there. My lord, he got beat some other court, my lord.
Once the bullet is triggered,
It doesn't come back, my lord. Yes, my lord.
what does it mean? Can you bring back? Nor you can divert the route.
But here, my lord, the thing is that erstwhile I didn't get instructions, and my lord, this is oath versus oath, my lord. I don't want to get into it at all. I actually don't want to get into it.
Don't you know when these things used to come when I was on that side of the room? What was my view on that?
I required, my lord, leave, my lord. Even if required, will be
Never.
My lord, actually, my lord, now, my lord,
Unless inquire from that advocate, if he comes in many of the matters, he comes and admits, yes, there was. No difficulty. No difficulty. We are quite conscious.
my lord, I understood, my lord,
He must be aware that what is being told or said or stated against him.
my lord, the difficulty, my lord, may I say, my lord, we face, my lord. Here, my lord, we are facing, my lord. My lord, we are hearing two persons, my lord. I cannot come and decide who is saying what. I cannot decide that fact.
What?
My lord, I cannot decide that fact who is saying what. My lord, one is saying one is saying one. My lord, I didn't want to get
When
into the space at all.
Something is said, then you'll have to at least make because he's a member of the bar.
He's a member of the bar, my lord, a close associate of mine even, my lord.
So
But more reasons, my lord, I'm saying, my lord.
more reasons is that no.
I don't want it to get into it at all, my lord. That is the reason I'm saying, my lord.
How many days delay?
71 days delay, my lord. That is the reason I don't want to get into at all with whatever is there, my lord.
Is one reason. Though in the petition nowhere anything is said, but there is one. The erstwhile
I've just
advocate
seen the
record.
mail. Mr. Malik just showed me the mail, man.
There are certain names which are given. Your name is also given. What I am of the firm view is always when a Section 5 or restoration,
Lordship allows it, I know.
when a Section 5 or a restoration is filed, and in that application, if there is certain aspersions made against the erstwhile advocate, that my firm belief is that unless he is made aware of the aspersions, we should not simpliciter proceed and allow the application. Because ultimately, we are accepting those aspersions and finding it as a sufficient cause, either for restoration or for condemnation. And if the lawyer comes and says, yes, this thing has happened, no difficulty. The second reason is why we call it that if these aspersions are accepted, the client or a party may go to the bar council and can make a complaint that these are the fault or the lapses or misconduct on the part of the advocate. Look, the court has also accepted him and condoned or restored. Look at his plight. He doesn't know anything. He did not get even a chance to defend before the court. So that's why we always give a notice, though he's not a party, but give a notice that you come and disclose. Sometimes they come and accept, no problem, in proceeding. Now this is a case where
No,
Several-
but from what I could see of the mail, my lord, I am not concerned
only
with
thing
what
is-
happened, my lord,
No, no.
between the advocate on record and my lord, the client.
There are certain things which are said about you as well. In
No,
this
but
mail.
that has nothing to do with the delay.
No. It is something that what happened and what was going to happen was happening between the client and the advocate. That advocate and record has also indicated that you are aware of all these facts. You are aware of.
Okay.
Can you read that?
Yes, my lord, kindly give me a moment, my lord.
The very first line, your name is there.
Yes, and that's correct. We endeavored to finish the matter. The assertion in the first line is nothing but contrary to what I've done.
The second line.
Yes, my lord. No, my lord.
Then
This-
third sentence.
No, my lord.
Then fourth line is
I'll
you.
tell you, my lord, what happened. There was some tiff between the advocate on record and the client. I am told he refused to pay the fees, which is
That
why
he
the,
has indicated
which
twice.
is why the tiff happened. I am told by him he didn't hurl abuses at me. There's no reason for me to make that aspersion.
That has not been said.
So no, I wouldn't know because he has written that abuses and I was offended.
Abuses somebody else.
No, he's saying he abused and I was offended by the abuse to somebody else. Now, my lord,
Obviously, because the abuses has been hurled to somebody.
Yes, that-
you should be offended.
that I was offended.
Yes,
When
you
that-
should be.
Yes,
That's
Yes,
the
my lord.
expectation from you.
that
you
is
should be offended.
correct. And that is when, my lord, I said, I don't want to do this matter. This is the attitude. I made it very clear. He, my lord, thereafter came to the chamber. He said, I'm very sorry. Please complete the matter. So I completed the matter. There was a second limb to it where he refused to pay fees because he said, no, not substantial hearing. So I won't pay the fees. So I said, very well, let us get it over with. Let me complete the matter since I've started. But beyond that, my lord, after the matter was over, my lord, I am not concerned with. My stand is clear, my lord. I have.
Madam, then how I will believe that paragraph 5 sentence? Because if that being the position that he was simply requested to continue with the hearing and put an end to the hearing. He put an end to the hearing and thereafter nothing was required to be done. It was your client who has to take immediate steps, which he took the immediate steps by taking all the briefs without taking a no objection. So if your client did not instruct the erstwhile advocate and record to apply for certified copy, how can you stand by that statement, omit it to file the certified copy? Tell me how you will justify the stamps. Because this letter says only, and Mr. Mitro also is very candid that only just to, since I have started, I must complete. He completed it and thereafter he has no role to play. Now he says that immediately thereafter the brief was handed over. Then where is the omission on his part? If the client does not instruct him to apply, is it a duty of the lawyer to immediately apply for certified copy?
Of ascertaining whether my client did in fact instruct the prior advocate on record to apply or whether it was an omission on his part. My lord, two things my lord is very much aware. The application for drawing up and completion is to be given within 7 days of the order being passed. My lord, today that means only this grey area, whether he was instructed to apply and he omitted, or since the client took away the briefs, he naturally assumed.
Obviously, immediately, that is what it says.
But my lord,
Immediately when the matter, they finished the argument, this was handed over.
my lord is aware the process of handing over is not so easy, especially on the original side.
No, it is always very easy. Somebody may take away the briefs. Only question is whether he has been, taken off or, the no objection has been given or not. This no objection was not secured by him.
My lord, in that
And later on, you called him up and then say, my client has executed. I am sending you a duly executed Wakalatnama. You put a no objection on that.
well within his right to withhold the objection. That is the practice.
No, madam. If you inculcate this, I am telling you wrong notion.
No, my lord, we kindly.
You can't withhold the no objection. If the client wants to withdraw, you should.
My lord does not take me amiss. My lord kindly allows me to complete. When I called him for the no objection, my lord, he was well within his right to say, look here, you send it, but this is the fact of the matter. None of this, my lord, if the issue comes
As a good advocate and record, nobody would say to another brother,
please inform me that there is no certified copy. He's taken away the brief.
No, because everything has been taken away. And when you take no objections, is it not your duty to see that what has happened?
Yes, my lord.
Yes.
Second, no,
Yes. No, it's not.
I'm immediately applied.
Then did you ask your client whether you instructed him to apply?
The submission was now, my lord. The only thing my lord, I request my lord to
Then it's an oath versus oath, and whom to believe? It's a I would say the legal fraternity whom we believe because they are the officer of the court.
I have
So disbelieving an officer of the court is a very tough task.
My lord, kindly, my lord,
No, definitely
kindly,
not.
lordship, my lord.
Definitely
My lord,
not.
does not go, my lord.
It will go a very bad message and a very wrong signal to the entire legal
My
fraternity.
lord, may I do one thing, my lord? May I do one thing, my lord? Kindly allows this, my lord. Kindly, my lord, let me withdraw, my lord. Let me take out a fresh application, my lord, with regard to, my lord. Or, my lord, let me amend it. Kindly give leave to amend. Because, my lord,
I tell you very frankly, we are very liberal. As Mr. Mitro has said, so far as a restoration, so far as a condonation, because our view is, and that is also a view expressed in many judgments of the Supreme Court, that at least let this matter be decided on merit. If there is some good matters on a limitation point should not be thrown out. If we can find certain grounds, it's a sufficient error. It's not that without any ground we can't. There are certain grounds which it's a question of belief and disbelief. But in these kind of things, that's the whole problem.
my lord,
The problem. Had it been some other thing, no problem.
my lord, what happened, transpired between the two persons, my lord, I actually know no one knows, my lord. That's the reason, my lord. One statement, my lord, as what my lord has already stated, it's oath versus oath, my lord. It's true, my lord. It's already indicated, my lord. Kindly, my lord, does not take any word, my lord.
It does not appear to be true. Because of this email, it does not appear to be true.
My lord,
And Mr. Mitro is also very, I would say, senior
yes, my
person.
lord, what my lord,
Yes, frequently. If he has said something, then how can you?
whatever he is,
Because he says that there was some disputes which was
There was
going on
dispute. I also know about the dispute.
between your client and the erstwhile advocate in the court. Because he was in the midst of an argument. Then your client approached him and say on a humanitarian ground that is said they please complete it. So I wanted that once you have started, complete it. He says no difficulty. Once I have started, only I will complete it and thereafter I will not take up any of your matters.
yes, my lord.
He completed the argument and immediately thereafter the entire brief was taken away or was handed over to your client. That is what the statements are. But he also said that he insisted that you take a no objection. He did not take a no objection.